In courtrooms across the country, legal decisions are made that can affect your life. Stay tuned and learn your legal rights and how to protect yourself, your business, and your family. Coming up next on Legal Minds. When you have a legal issue or question, sometimes it's difficult to get through the process. There are many meetings to attend, many documents to go over, and much terminology to learn. But understanding your rights is important. And today, we'll hear from some of the area's top legal minds who will provide you with valuable information on a number of legal concerns. Being accused of committing a crime can change the life of you and your family. The steps you take during the legal process can sometimes mean the difference between incarceration or freedom. In 2004, according to the Department of Justice, approximately 2.1 million people were in jails or prisons, and 4.9 million more were in some form of community corrections. In order to prepare your defense, your legal counsel is key. Let's hear more from a local attorney.
Anybody that's accused of or the police have arrested or wish to talk to, you definitely need a criminal defense attorney. The police are not there to protect your rights. The police are there to build a case against you. And you want to consult a qualified criminal defense attorney that can protect your rights. The system is up against you. It's you against a system that you're unfamiliar with. We know all the judges. We know the district attorneys. There are good judges, in my opinion, and bad judges, in my opinion. One of the things that people don't understand or realize right off the bat is that by hiring a lawyer, it can protect all your rights. When you first go to court, you're going to be assigned a circuit court judge to represent you. You have the right under the Constitution of this state to request a substitution of judge. In other words, if you get what's so-called a hanging judge, we know the good ones, we know the bad ones. We can substitute that judge and get you a judge that, in our opinion, will be much more fair to hear your case. Without knowing those rights, you could be slotted into a court where your result is going to be very bad. In Wisconsin, if you're accused of any felony offense, you could go to state prison. Another reason I hire a qualified, experienced defense attorney is many times we're able to get felonies reduced to misdemeanors. With a misdemeanor, unless you're charged as a habitual criminal, you cannot go to prison. On top of that, job applications. If many employers see a felony, the door just gets shut in your face. Many times we're able to convince or talk the district attorney into reducing a felony to a misdemeanor. That will have a wide impact on the rest of your life. It'll open more job opportunities to you. You could possess a firearm if you wanted to. You could do law enforcement jobs. But once you're convicted of a felony, in this state, you no longer can vote while you're under supervision or serving your sentence. You cannot possess or own a gun, and many job opportunities are shut to you. So, especially if you're charged with a felony, you want to consult an attorney immediately. The initial process is obviously you become a suspect. For some reason, shape, fashion, or form, the police have drawn their attention to you. At that point, you're considered a suspect. Police try to interrogate you to get a statement from you. They forward their reports to the DA. Eventually, the DA decides to issue a charge or not issue a charge. If you're issued a charge, that means you have to go to court. Bail is set. You're assigned a judge, and then the legal proceedings start. You should pretty much be thinking of a lawyer at the very first point of time that the term suspect comes above you. The police call you, come by your house, knock on your door. At that point, you should really consider hiring a lawyer, because at that point, the police are focusing their attention on you, and you obviously don't want to be unrepresented. There are a lot of ways to find an attorney. Sometimes attorneys in the family, sometimes a friend refers you an attorney, but I think results probably speak volumes. At this firm, we've had over 160 trials. Well over 100 of those are jury trials. We've beaten homicide cases, sexual assault cases. You name it, we probably won it in a court of law. Some attorneys will tell you, yeah, I've beaten that case, but have them prove it to you. At DeRuta and Forrestal, if you want to see our record, we'll be glad to show you every case that we've tried and every case that we've won. We're qualified attorneys, as I said, over 160 trials, whether it's a jury trial, a court trial, or if your kid's in trouble, children's court trial. You need a qualified attorney. And just because a family friend might be an attorney or somebody might refer you to an attorney, maybe they don't concentrate in criminal defense like we do. What we do day in and day out is criminal defense and traffic defense. We don't do any other area of the law. Sometimes you go to a lawyer that might be a pretty good guy or woman, but they don't concentrate in this area of the law. That lawyer is not going to give you the same representation as we will. Day in and day out, we're in the trenches, we're fighting these battles, and we're getting winning results for our clients.
Legal matters can take months or even years to resolve. As time elapses, details sometimes get lost. This is why keeping accurate records of the events of your case can be very important. Make sure to take timely notes of all pertinent dates, times, places, and names involved in your complaint. When you meet with a legal counsel, having accurate records can assist in accurately presenting your case. As time passes, so can very important information, but having accurate records can be extremely valuable. Sometimes in life, things don't go as planned. What would you do if your planned marriage ends up in divorce? You may have some major decisions to make with your children, your home, and your finances. Decisions that not only affect the present, but also your future. Having a legal counsel on your side during this difficult process can provide you with valuable insight. Let's talk to a local attorney who will explain more.
In Wisconsin, there are 3 ways to end a marriage: a divorce, an annulment, or a legal separation. All 3 are lawsuits. The annulment option as a lawsuit is rarely used in Wisconsin because the standard for proving an annulment is very, very strict. We, as a team at D'Angelo and Jones, with the assistance of our legal staff, most frequently help clients with a divorce or a legal separation. The only legal difference between a divorce and a legal separation is at the conclusion of the action, at the conclusion of trial, when the court grants a judgment. If it is a judgment of legal separation, the parties cannot remarry until a divorce is granted at a subsequent time. This is also a no-fault divorce state, and what that means is that there is no acceptable proof to the court other than the fact that the marriage is irretrievably broken as grounds for a divorce, annulment, or legal separation.
The primary focus of any divorce in which the parties have minor children is to develop a parenting plan that addresses the best interests of the minor children. Generally, there are 2 decisions that parents will need to make with regard to the children. The first is legal custody, and that is the determination as to who will get to make major decisions in the child's life. Whether or not the child could get married or join the military before the age of 18, non-emergency medical decisions. The court can award custody either solely to one party or jointly to both parties. The second decision the parents are going to need to make, and generally the more contested decision, is one of physical placement. That means where the child resides and who the child is with at any given time. There are actually 16 factors in the state of Wisconsin that the court looks at, or the parties would look at, to determine the best allocation of periods of physical placement. The ultimate determination is what is in the best interest of the minor children. And the goal is really to give the child regularly occurring, meaningful placement with both parents that maximizes the amount of time that a child can spend with both parents. However, maximization does not mean equalization.
When parties are going through a divorce, there are several types of support that the parties may agree to or a court may award. And those would be child support, family support, or maintenance. And a lot of you know maintenance under its other name of alimony. It's important to remember that when calculating these supports, the income or potential income of both the husband and the wife is likely to be taken into consideration. And much like the other matters that my colleagues have discussed previously, there are several statutory factors that the parties and the court will be looking at when making these various support determinations. If you would like further information about any of the laws that we've discussed today, please feel free to visit our firm website at www.d'angelojones.com.
When appearing in court, it is important to know the definitions of commonly used terms and phrases. A court order is an official proclamation by a judge that requires that certain actions be completed by one or more parties to a case. It can be as simple as setting a date for trial or as complex as restructuring contractual relationships. The defendant is the party who has been formally charged or accused of violating a law. Researching legal terms prior to your court date will make you more prepared for your legal experience. For more information regarding these legal issues and more, log on to this website. Stay tuned as Legal Minds continues after this.